Hey guys, Dark Angel here. May 10th, Wednesday, day 2. So, I hope you're strapped in, got your coffee, you're ready for the ride. We're going to have a good one today. Uh, as I've already told you, or mentioned to you, I should say, uh, we are reading into some good juicy stuff that I'm not even going to try to expose the name. Actually, I can't even expose the name because, like I said, the individual who sent me this what I'm reading from, uh, remained anonymous. But in reference to them having left themselves anonymous, they also explained that they wanted this to get out. So, you know, and I guess they felt that I was, since I am such the active advocate to our rights, which you have thousands who are, and you have thousands of them who are way better spokespeople than what I am. I mean, I'm just, I'm just another guy in the group that tries to come along and do what's right. Uh, I guess maybe to a degree I have a good teaching sense. I guess you can say. I'm not really sure as to what inspired this individual to want to send me this manuscript when I've seen videos with guys and girls on here that speak way better than I do. So I'm not one of the best uh, speakers in the world. You know what I'm saying? As a matter of fact, I don't even actually categorize myself as a good speaker at all. Unless it is in person, and then you know I can get pretty good in explanations. My wife says it all the time. She says, "Man, you should be doing public speaking." You know, but when I get on these videos, it's like a totally different. You know, so I don't know, and it's crazy, but it's it's something that I like to do, and I'm really trying to get. I love what I'm doing and I like getting it out there. So, if you like what I'm doing, you know, then go ahead and hit the like buttons, hit the subscribe buttons. Uh, and like I said, this channel is mainly for trolls, traders, bootlickers. This is mainly for you guys to get on here and because I noticed that a lot of you have your own points of views. A lot of you want to dispute facts, you know, and in my opinion, that would be just wasting your breath to sit there and try to dispute facts that are laid out before you. That, to me, that just doesn't remotely compute in my head as to why someone would want to sit there and dispute facts that they know they can't provide any proof to dilute the facts. That to me that just doesn't make sense. But hey, to each their own. It's what you like to do. So be it. You know, an opinion's just like an asshole. Everybody has one. You know, and the way I see it is, you know, there's so many things in life we can waste our time on. And one of the things that I've learned over time is never waste your time on something that has already been established and proven. If it's already been established and proven, what's the point in sitting there trying to dispute what's already there? That just, to me, it's just a waste of time. But back to the situation at hand, I want you to remember: evoke, demand, protect. Where no policy or statute is made, no law can be enforced, and no jurisdiction exists. Those are the keys for what we're going through today. What we're going through for the next few days, I should say. Where no policy or statute is made, no law can be enforced. Meaning, if there's not a statute or a policy, how can you enforce a law? You could misapply the law and try to say that it conjoins with that statute or alleged policy. However, if the statute does not mention or direct you to that actual action, there's no law for it. So anyway, I want to go ahead and get off into this because we got a lot to cover today, and I just want to go there. So I'm going to pick up where I left off yesterday. There exists considerable authority on the subject of deprivation of the liberty of an individual using the roads in the ordinary course of life and business. However, it should be noted that extensive research has not turned up one case or authority acknowledging the state's power to convert the individual's right to travel upon the public roads into a privilege. See Miranda versus Arizona Supra. Did you hear that? Not one authority has ever been found that acknowledges and or gives the state the authority to turn a right into a privilege. And you get so many people on here, they're always talking about, well, it's not a right, traveling has never been a right. No one's ever established that. Either you don't know how to read or you're just that incompetent, which actually categorizes you as both. So there's that, but the bottom line is there is so many cases established on all three levels of the court process that it's ridiculous. Therefore, it is concluded that the citizen does have a right to travel and transport his property upon the public highways and roads, and exercise of this right is not a privilege. Driving is not traveling. Absent express language to the contrary and proof of allegation notwithstanding the static eccentricities, no conviction may be lawfully sustained or upheld. But yet these courts manage to do it. And they only manage to do it because of the simple fact is we allow them. Remember what I said. Where no policy or statute is made, no law can be enforced. And no jurisdiction exists. Remember that. Nohom simile este indum. Things that are similar are not identical. Expressio unius este exclusio ulteriores. The expression of one thing is the exclusion of another. So, that's pretty much self-explanatory. That if you have a chameleon, when you see the chameleon, when he changes his colors and blends into his habitat, his background, he's playing that game. Now you see me, now you don't. And in reference to that, now you see me, now you don't. That's pretty much how the courts is playing. They're playing chameleon with you, with us, I should say. I'm not by any means excluding myself from this because I am also part of the system as well. So that includes myself. So when it includes myself, it means that I'm probably going to go through the same things as well. Don't get me wrong. Police do pull you over. They talk, and they want to try to chit chat and convince you that they're your buddy. And it's like I tell them, I do have friends in uniform, and I respect them very well, and they respect me to the point to where when they see that I'm doing what I'm doing, you know, instead of them criticizing, they actually they engage in conversation with me because they want to see where I'm coming from. And then when I sit down with them and actually have a cup of coffee with them, uh, they actually learn something that they didn't know. And unlike a lot of officers that they take the information, they absorb it and keep it, a lot of my friends, they actually would engage in upper ranking officers, older officers. And they would go to them and ask them, hey, is any of what I've been told true? And I've had captains, lieutenants, uh, chiefs, for that matter, tell them, yeah, what he's doing is correct. What he's doing is right. It's 100. You know, I've never had not one officer come back and say that what we're doing or what we stand for is immoral. You know, now granted, they do not like the idea that we're going against what they say because according to them, they are the law. Well, how can you be the law if you don't even know what the law is? That doesn't make sense to me. You call yourself a law enforcer. Well, let's break that law enforcer down for a minute because statutes are structured under color of law. Statutes are also administrative policies. So let's go to police. Police. Hmm. Police. Well, how do you spell policy? Policy. So you take the polic in police, switch out the Y to an E, it's policy enforcer. It's exactly what that means. You see what I'm saying? So a lot of people haven't made the connection with police and policy. Polic, policy, E, enforcer. So all they are is administrative enforcers. That's all they are. You know. And if you really want to get technical, we can say since they are uh, titled servants, their title is to protect and to serve. When have you ever known a servant to have authority over another? Servants don't have authority over another. Their masters are who administer the law that they are supposed to take out and enforce. Okay? But when it comes to our person, we are our own masters. We are not governed by another human being. We are not governed by a human body. Our body is our vessel. This is the vessel that we have. And the vessel that we have, we must take care of it as our own because of the simple fact, I like to say that it's our vessel on loan. We're borrowing this vessel. And what we do with this vessel during our time here is, how it's going to come to the end days. You know, uh, will you go to meet your maker with a complete body, a hole in your body? Will it be a natural passing or what? I mean, I'm rambling on about that, but that's neither here nor there. But it does kind of have a little light into who we are as human beings. So, as human beings, you know, the world. the world has been separated into categories, you know, but under the human race, we are one, you know. So I'm not going to get off into all that because that's a totally different conversation for another time and another means. But Jesus, I mean, we can go on for days with that, you know. But yeah. So just remember, we're all gods within our own rights. The Bible even says so. If you follow the Bible, if you believe in the Bible even says so. Once you get into theological aspect of the Bible, it actually explains to you the definitions between a capital G God and a lowercase g God. So lowercase g God meaning man God. So if you go back to the history where God specifies that he has created man in that of his own image, with him being a God, he created the lowercase man, God, man. So, you know, and you know what? It was funny because I mentioned that in a previous video, and I've actually had somebody who they were like, I never knew that. I never even heard of that. I'm go into your theological studies, and you know, and it'll show you that. You know, but anyway, back to this session. No person shall be deprived of life, liberty, or property without due process of law. The courts at many levels have firmly established an absolute right to travel. The state, by applying commercial statutes to all who would use the highways, has deprived the common traveler of the right of liberty without cause and without due process of law, meaning they failed to give anybody notice. As you know, before you can be charged, you have to be given notice. Before something can be enacted, it has to be given notice, right? The essential elements of due process of law are notice and the opportunity to defend. There you go. See, and y'all have to excuse me. I'm fighting allergies, so whew, man, these allergies they kick my butt sometimes. They really do a number on me. So you hear me snorting and going on. That's I don't mean no disrespect by it. You know, it's just the allergies. It's got my sinuses all bleh. And actually today I actually feel like bleh. So you know, but that's neither here nor there because the message still needs to get out. So with that being said, the message continues. Yet not one individual has been given notice of the loss of the right to travel the roads and highways, let alone before signing the driver license application or the application for for vehicle title. To defend against the potential loss of the right to travel by automobile on the highways, the traveler must be armed with the knowledge that there was an intentional concealment by the Department of Licensing, the DOL. Department of Licensing. Remember what I told you. The United States is a corporation that actually erected corporations within itself. The DOL being one of them. The DMT, okay, Department of Transportation. All these entities are entities within the entity. There should be no arbitrary deprivation of life or liberty. Barber versus Conley and Yik Wo versus Hopkins. The right to travel is part of the liberty of which a citizen cannot be deprived. Without due process of law under the Fifth Amendment, this right was emerging as early as the Magna Carta. Kent versus Duels. I actually have that Kent versus Duels case, and it's alleging here that the case was actually erected in 1958, and I actually do believe I have a version of the case that is citing it from from the 60s. So I do believe that the Kent versus Duels case, in reference to what it is alleging here, was actually founded in the 50s. Let's see. The right to travel is a part of liberty of which the citizen cannot be deprived without due process of law under the Fifth Amendment. If the liberty is to be regulated, it must be pursuant to law making functions of Congress. Freedom of movement across frontiers in either direction and inside frontiers, as well as part of our heritage. Travel abroad, like travel within the country, may be as close to the heart of the individual as the choice of what he eats, or wears, or reads. Freedom of movement is basic in our scheme of values. And that's 62 CJS Municipal Corporations 148, citing Kent versus Duels again. Since the state alleges and forcefully alludes, now listen to this. This is what I was talking about the manipulation. Since the state alleges and forcefully alludes that one give up the right of traveling in order to exercise the privilege of driving, the statute regulation cannot stand under the police power, or due process, but which must be exposed as oppressive by misapplication and misrepresentation to deprive the citizen of rights guaranteed by the United States Constitution and the state's constitutions. Now, as you saw, as you heard earlier, it clearly separated driving, traveling, clearly. And you hear people always arguing all the time. No, driving, traveling is the same thing. You're in possession and in operation of in control of an automobile. Da 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 da. Okay, you can say that. You can say that till your heart's content. You can say it until you're blue in the face. You can say it till the day you walk to your grave. But the bottom line is the Supreme Court says driving and traveling are distinctively two different actions. I didn't say it. The Supreme Court said it. The right to travel may be restricted, regulated, or alienated. No state or court of any jurisdiction, neither any legislative body, not one in this country, has authority to require an individual to apply for a privilege. The state may have discretion to grant or withhold the business privilege. However, it is the sole discretion and proprietary interest of the individual to even reach the point of making application. Meaning, it's your choice. If you decide that you want to go do it, go do it. If you don't have to. There's no law that says you have to. See, there is no law. There's statutes that say you have to. And ladies and gentlemen, for those of you that don't know, statutes is not law. Penal codes, those are not law. Those are guidelines. Guidelines. The police have you so corrupted and so brainwashed into believing that statutes is law. They're not law. They never have been law. They have never been established to actually say that it is law. You know, what has been established is the fact that the courts cannot distinguish the difference between a right and a privilege. You know, the distinction can be simply stated as an individual has a right to do that only which affects and benefits him, but no one has a right to do that which affects the community. The rule of travel is the same as the rule of standing. The rule of standing simply stated, saving further elaboration. I don't know. Saving further elaboration. Duh. Like I said, guys, just bear with me, okay? My senses and everything is off today. I mean, really off. I've waited until late in the day to actually film the second video because I was just feeling like blah. So, elaboration says a person may only sue on their own interest. Remember when I was reading the Hendricks versus Maryland case where he tried to bring suit of discrimination in his traveling without a license registration in the case, and he was trying to bring up that the statute of Maryland was discriminative. But the only issue about that was, and I said that I agree with the courts on the fact that he couldn't bring suit based on the fact that the discrimination did not initially impact him as a person because of the fact that he was not from Maryland. He was actually from, I think it was like Queen's Court, King's Court, something like that. I don't remember off the top of my head, but he was actually from another area and drove into this area and didn't have what they would have presumed back then as the proper documents for his vehicle. So he tried to raise suit for discrimination, and he couldn't do it because it didn't effectively affect him. You see what I'm saying? So he was more or less trying to bring it up on behalf of the people. You can't do that, you know, unless you have a petition, you know, in that respect, and you petition the court to that respect, and then all them people sign the case. You see what I'm saying? They all get involved in the case some kind of way. In this respect here, same thing, you know. So which affects the community. The rule of travel is the same as the rule of standing. The rule of standing simply stated, saving further elaboration, says a person may only sue on their own interests and may not sue on the interests of the people at large. The distinction between a right versus a privilege to use the public roads is drawn upon the line of using the road as a place of business, and the various state courts have ruled as much. The U.S. courts equally held to this point. United States courts, y'all. The first, it is well established law that the highways of the state are public property and their primary and preferred use is for private purposes, and that their use for purpose of gain is special and extraordinary, which generally, at least, the legislator may prohibit or condition as it sees fit. They're not telling you that it can be uh, prohibited or conditioned as the use of a private traveler. They're telling you that it can be conditioned or prohibited as the use of the extraordinary conditions. Man, I just said that all wrong. Okay, so special and extraordinary use, meaning commercial, commerce. That's what they're referring to. They're referring to being able to condition or prohibit it from being able to do that. You know, not as a private traveler. As you see when you read the law, it actually eludes. It goes to private travel and then immediately eludes private traveler right into extraordinary, special and extraordinary use. And then it goes into express deeper about special and extraordinary use. But as you see, even though the law does mention private traveler, that the public roads are made for private travel, that's about as far as it goes with that law. The law does not go and extend out to any further reference as to what can and cannot be done as a private traveler. You know, what law says that? There is none. Anyway, you can find that in Stephenson versus Benford, Packard versus Batten, Frost and Frost Trucking Company versus the Railroad Commission, Railroad Commission versus the Intercity Forwarding Company. Let's see, Parlett Cooperative Inc. versus Tidwater Lines, And again, you know, like I said, everything that I'm reading to you straight from the Supreme Court. These cases here are the cases that they didn't want you to know, and they are actually showing you the difference. They are actually distincting the difference between driving and traveling. You know, a cop could sit there until he's blue in the face and tell you all day, yeah, under this statute, I'm gonna go ahead and write you a summons, write you a ticket. But you know, if you go into court and you argue the jurisdiction, a lot of the judges will try to find you in contempt of court or obstructing justice because they do not want to address the issue of jurisdiction. I've seen it. I've seen it, I've heard it, and I've had people tell me about it. Oh, yeah, they found me in contempt because I kept bringing up the issue about jurisdiction. Okay, well, it's your right because here's the thing. If they misapplied the law, you need to appeal the case. Because if the statute that they're utilizing in reference to your case is does not address your immediate issue in the case, that's a misapplication of the law. The courts are very known for doing that. So, so what is a privilege to use the roads? The distinction has been drawn between traveling upon and transporting one's property upon the public roads, which is our right, and using the public roads as a place of business or a main instrumentality of business, which is a privilege. The roads are constructed and maintained as public expense, and no person therefore can insist that he has or may acquire a vested right to their use in carrying on a commercial business. Ex parte Sterling, Barney versus Railroad Commissioner, Stephenson versus Benford, Supra. When the public highways are made the place of business, the state has a right to regulate their use in the interest of safety and convenience of the public as well as the preservation of the highways further. The state's right to regulate such use is based upon the nature of the business and the use of the highways in connection therewith. Thompson versus Smith. We know of no inherent right in one to use the highways for commercial purposes. The highways are primarily for the use of the public, and in the interest of the public, the state may prohibit or regulate the use of the highways for gain. Robertson versus Department of Public Works, Supra. Wholesale licensing is accomplished under the guise of regulation. Remember, I was telling you about the licensing, people. We're getting ready to start getting off into some of the licensing issues. The Department of Licensing never asks what the name of the business is. They automatically assume the person is the business. This statement is inactive in and of the state's perseverance to ignore the limits placed upon governments by and through the several constitutions. Further discussion of this is found in public disclosure herein. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. U.S. Constitution. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda versus Arizona, 384. The legislation or legislator does not have the power to abrogate the citizen's right to travel upon the public roads by passing legislation intimidating the citizen to waive his right and convert the right into a privilege. Furthermore, we have previously established that this privilege has been defined as applying only to those who are conducting business on the streets or operating for hire vehicles. Supreme Court. And Miranda versus Arizona is like a landmark case. So, now, hang on now. The legislator has conspired by legislative obfuscation to deprive the citizen of his right to use the roads in the ordinary course of life and business without affording the citizen the safeguard of due process of law. This has been accomplished under elusive powers of regulatory authority. In addition to the requirement that regulations governing the use of the highways must not be violative of constitutional guarantees, the prime essentials of such regulation are reasonableness, impartiality, and definiteness or certainty. See, and the one that I've seen a lot, or the two out of these that I've seen a lot, is reasonableness and impartiality. Because of the simple fact they'll say that, oh yeah, well, issuing a license was reasonable. The issuance of a license, it was reasonable. Okay, well, yeah, but it is only reasonable in that of your business, because there is no established law that says a license is reasonable against my rights to travel. I don't know where y'all come from or where you come from, but in my experience, no means no. And in the Constitution, where it says no government encroachment, that leaves no room for speculation that even reasonableness cannot be applied to the word no. No means no. That means no, you can't add nothing, you can't take nothing away. No. No government infringement. Your reasonable application of a license to my rights does not apply because there's no jurisdiction for it. Because no means no. Again, it goes right back to the same what I was saying, where no policy and statute is made, right? No law can be enforced. There is no statute for private automobile having to be licensed. There is no statute. There never was one. There cannot be one made. You could take that up to the legislation all day and all night. The 14th Amendment specifically says that a private citizen is protected against government intrusion as to their private affairs, that the government does not have any control over their affairs, meaning they do not have jurisdiction over a private individual. It says it in the 14th. You can read that. So let's move on. Moreover, a distinction must be observed between the regulation of activity which may be engaged in as a matter of right and one carried on by government sufferance of permissions. Davis versus Massachusetts, Packard versus Banton, Supra. The only limitations found restricting the right of state to condition the use of the public highways as a means of vehicular transportation for compensation are: one, that the state must not exact of those it permits to use the highways for hauling for gain that they surrender any of their inherent U.S. constitutional rights as a condition precedence to obtaining permission for such use. Riley versus Lawson, 143. Stephenson versus Benford, Supra. So there you go. That case right there actually shows you that these, like I told you, these cases that I'm reading to you, these are case laws that were hidden. They were buried because they didn't want the exact story to get out. But you got to remember, the highways, the state is a business. Anything contradicting business, they don't want you to know about that because you're taking away their money. So they're telling you right here that there is actual ways to get around their money. And the interesting thing is with this is, when this was sent to me, I couldn't believe it when I was reading it. I was just like, oh my God, So the state does know about everything that people who, us who are fighting for our rights, they do know. They don't want you to have them, you know. And when they figured it out, that we figured out what they've been doing, you know, they're actually not even scrambling to try to cover it up, you know. But what they are doing is they are, in the best possible way they know how, stopping our actions by manipulating words. And if you fall for the manipulation, you know, that's pretty much about as far as it's going to go. But you have to learn to discern the difference between certain words, such as that expression that I read earlier about what may seem as is the expression of one thing is the exclusion of the other. Things that are similar are not identical. Got to keep that in mind, because the state likes to manipulate those words and put them in there and make you believe that they are the same when they're in fact not. We find it intolerable that one constitutional right should have to be surrendered in order to assert another. Simmons versus the United States, 390. The promulgation of core terms including inter alia and terms road, street, alley, and highway, whether it be denominated a freeway, is and are cohesive. A road is defined generally as an open way or public passage for vehicles, persons, and animals, a track for travel or transportation to and for serving as a means of communication between two places, usually having distinguishing names. Webster's Third New International Dictionary. In common parlance, therefore, a road is a thoroughfare intended to facilitate travel, including vehicular travel. Furthermore, that the state may, under the police power, regulate travel upon the public highways cannot be doubted. Silver versus Silver. Above, the court stated to facilitate travel, including vehicular travel. The court so stating confirms that vehicular travel is a separate and distinctive activity from mere travel. It is further stated below, for the purpose of travel and commerce. This conclusively solidifies that there are in fact two distinct and separate uses, one public business, the other personal private travel. Yeah, I didn't even know that, but well, I did, but I did not know that that case existed. The right of the public in a common highway is paramount, and controlling this right extends to the entire territory within its limits, and an obstruction placed upon any part of it constitutes a public nuisance. So see, I think it was earlier in the first reading, maybe hadn't covered it yet. Uh, the police and the state power considers you who enforces your rights, us, to be a nuisance. And we are a nuisance to the degree of we're interfering with their business. When you enforce your rights, or you invoke your rights, and you evoke um, demand and try to protect them, you are a nuisance. Hence how you become enemy of the state. And now you're a domestic terrorist, because now you've been labeled a domestic terrorist for the fact that you are trying to evoke, demand, and protect your rights that were given to you. They don't want that because you're infringing upon their business. Let them tell it. That's the reason why you become a public nuisance. Hence the tickets, hence this, that, and then when it gets to that point to where they give you the tickets and you get so many tickets, they want to suspend your license. And then now they have said, now by suspending your license, you are no longer a public nuisance. So therefore, you can't infringe upon that of our business. But I mean, that's just my opinion. I mean, if it can be explained a little better, someone step up to the plate and give it a shot. Let's see. Let's move on. The fundamental idea of a highway is not only that it is public, but that it is public for free and unmolested passage thereon by all persons desiring to use it. In keeping with the recognition that business can be dangerous to the public and the tendency or likelihood that drivers could be dangerous to the public, thusly must obtain special training. It has been ruled that the usual and ordinary use of an automobile is not dangerous. A former Washington Attorney General addressed this point later herein. Okay, now, do you remember when I was telling you about the training? Yes, you have driving school. Yes, you do have driver's school for, when you get out of when you're in high school, you go to driver's ed. Okay. And then if you get so many traffic tickets or something, they want you to go to traffic school, which in fact does not. Traffic school does not teach you safety. It just teaches you the rules of the road, which in part are not really, in my opinion, safety. I pulled out this book again to continuously remind you guys that federal motor carrier safety regulations. Okay. I keep pulling that book out. And I'm going to continue to pull it out until it gets in y'all's heads that these cases, they're referring to this. They're referring to this book right here. They're referring to that. Okay? They are referring to that book when they talk about safety of the public, etc., etc. That is the only thing they're allowed to regulate. Oh, and by the way, in an event that you did not know, this is business. This is the state's business right here. A lot of people did not know that. That's just the federal regulations. You're right, it's their business. This is their commercial business, their commerce, their movement for hire, their movement for gain. It's right here. This is it. This is what they are referring to. They are not referring to anything else. Anybody, I challenge you. You have a book out there. A book out there that shows that it governs private automobiles, public transportation. Show it to me. Put it down in the comments. Post it. I haven't seen one yet. And I've been doing this for a while, and I have not seen one yet, and I've had nobody come forward. Not a lot of people are on my channel, but that's okay. But I do know that a lot of people do view my channel, and they view it, and they want to leave, derogatory comments. But like I said, this is for you. This is for you that likes to leave those comments, because I'm going to be on it. I'm going to be on it. Because everyone's entitled to their opinion. And I'm not going to disrespect you over your opinion, but I will friendly debate with you over the facts. Because the funny thing is the whole time that I've been doing this, I've provided nothing but facts. And then you get guys on there, they'll cite several cases, and they'll put a whole truckload of cases on there. And then when you go to read the cases, they're all in relation to business and commerce. So they don't even know how to interpret what they're trying to preach. They don't even know how to interpret a simple law, basic law. And they don't even know how to interpret it, but they're trying to tell you it means this or it means that, when, if you want clarification as to what it means, Look the terms up in the Supreme Court definitions. Look the terms up in the federal definitions. You know, look them up. You know, obviously you didn't do too well in school because you can't even discern the difference between a right and a privilege. So, what makes me believe that you know how to discern what a case law is saying, let alone a right and a privilege? Come on now. The customary, usual, or ordinary use of the street is for travel from one point to another, both along and across it. The use of the street by an automobile, when operated with due care and caution and not in violation of state or municipal police regulations, would be deemed a proper and lawful one. Huddy on Automobiles, 6th edition, citing Jenkins versus Goodall. As shown below, when using by whatever phraseology the terms, word, or phrases commonly used in the English language known as motor vehicle and motor automobile, they are used by the layman in a generic sense. But when used in law, they are defined and confined to have a narrow and particular meaning in order to conform to a specific intent. The term motor vehicle is not necessarily synonymous with the term automobile. Huddy Automobile Law 9th edition, definition and distinctions. A mule team, a golf ball, or a nail may be driven. These are generic idioms of driving. Legally speaking, though, a drive is a more specific and intentional act as discussed in licensing later on. The same is true for motor vehicle, which generically describes any of several genera of motorized vehicle which are self-propelled by an internal combustion engine or an electric motor, or as now in the 21st century, hydrogen engines. Motor vehicle is a broad term that has no universally accepted meaning. It has been considered to be much broader than the word automobile and to include various vehicles which cannot be classified as automobiles. American Jurisprudence, 2nd, automobile at 2. An automobile may be purchased from an automobile dealership or a private party when such automobile is proffered for sale, and yet the purchase of the automobile itself does not trigger a commercial kinship. The dealership did not proffer for sale a motor vehicle as defined by statute, as stated by the Dunkley Court, infra. It is not the possession of the vehicle that is subject to regulation, rather it is the intended use. Personal use of a personal property automobile is not chimerically chimerically. I would say that's chimerically. Whatever that means, I don't know. But I will look it up and find out. Representative of a governmentality regulated activity merely because one may use it on the common highways. The definition of motor vehicle found in both the federal regulations and those of the state of Washington are strictly construed and confirmed to the use of an automobile in a commercial aspect, meaning the remuneration for service. Well, see, I didn't even know that. So, but when I was reading the RCW, it kept referring to motor vehicles. Matter of fact, I don't believe that in the RCW 4620 there is no mention of automobile in the whole chapter. It keeps referring to motor vehicle, which when you take that and align it with the federal regulations under Title 49, they match. So that goes back to the argument of the state is commercial. A license is commercial. Because if the regulations for the feds specifically identifies a motor vehicle as being that of one used in commercial activity, then the statutes and the definition for motor vehicle would be one and the same. Just saying. Just saying. Now, let's see. Let's continue. The word automobile expresses its own meaning, and generally it is to be taken and understood in its ordinary and popular sense. America's Jurisprudence, Second Automobile, 1, Huddy Automobile Law, 9th edition, Definitions and Distinctions. Judges have the general consensus of other people as to the terms relating to the use of automobiles. A motor vehicle must have designed for use or be used to transport persons and property over the public highways. It is well known by the state and its agencies that there is an absolute distinction between private travel and commercial travel. It seems like they did that yesterday too. As I was in the middle of doing this, they all of a sudden decided that they wanted to start cutting grass and doing all that stuff. Private travel and commercial travel. When versing a Motor Vehicle Act, it is critical that the definitions used therein are strictly adhered to. It is further inextricably technical that in order to enforce the Motor Vehicle Code, the state by any branch must adhere to and comply with the whole Act rule. Any precaution, civil or criminal, commenced pursuant to the Motor Vehicle Act must be in fact commercial, and it is the sole obligation of the state to prove that the act in question was in fact commercial. What I was just saying earlier, the entire DMV, DOL, the entire license process, the whole thing, it's commercial. It's always been commercial. It's never been nothing but commercial. And I've been stressing that, trying to get people to understand, look, man, these cases, you do not have to go do, and no disrespect to the brothers and sisters that practice, being foreign nationals and all of this and that. You don't have to do all that. You do not have to. But if that's what you wish to do, then more power to you. And that's your right to do as you will, because it is your right as a citizen to do what you want. But the power is yours. You own the power. The power doesn't belong to no one else. And knowledge is the key. It's not about who you are. It's about what you know. The bottom line is when you go into those courts, if you do not understand or know that the substance of a statute is written in that of a commercial capacity, you'll lose the case every single time. You have to know and understand that the statutes, policies, they're all written in a commercial aspect because this is a business. This is a business. They've taken the United States and then the Republic of the United States and separated the two, which they've always been separated, but they distinctively separated the two. Corporate United States, you need a license to do anything. You need a license to operate in our corporation. Yeah. And it's true, you do. You need a license to operate in their business because of the simple fact they have a security interest. And you can't deny them their security interest because, one, they want to know what you're doing, how much you're making, how much you're going to end up paying them to operate that business within their capacity. They have a security interest. Hence the reason why when you register your automobile, they want a security interest, because when you apply for the license, when you apply for the title to that automobile, you have now entered into a contract with them, the state, giving them a security interest in your automobile, because you as a person is a business to them. It has been distinctively defined that a corporation and an individual are distinctively two separate things. And the state defines its people as businesses. And when you go into the court, you have to separate the two. You have to show the court that I'm not a business, I'm not a corporation, I'm an individual. See, that's something that a lot of people, they have no idea what are you talking about. Look it up. Look it up. The corporate United States of America distinguishes you, has defined you as a business. They say you are a corporation. I'm an individual. I'm not your business. I'm not in your business. I'm not part of your business. Now, if you work, you pay taxes, all that good stuff, then you are part of their business. You know, just saying. That's just common law. So, I'm not. I don't pay taxes. Haven't for, damn, going on 6 years now. 6 years. Yeah, about 5, 6 years now. So, yeah, I don't pay taxes. And I've showed you guys the picture of my automobile. I don't have plates on it. I actually had a guy, funny, interestingly enough, this older gentleman was walking by, and I was just happened to been sitting outside, and he says, "What state are you from?" And I was like, "Excuse me?" He says, "What state are you from?" And I was like, "Well, why do you ask?" And he's like, "I've never seen black and white license plates before like that." And I was like, I'm not like that, because one, it's my own personal business, but to keep it in respect to the conversation, I wasn't trying to be disrespectful towards the elderly gentleman, because one, I don't know him. I don't know what his purpose and intent was by asking that question, and I don't know if he was going to go take that information somewhere, which personally I don't care, because I'm prepared to deal with any court dealings that should happen to come my way. I am fully arsenal, to take a case into court and beat it, and you notice I said beat it. I am confident, 100% confident, absolutely 100% confident, that should ever come the day come along that a cop's ego decides to get the best of him, and he decides to follow through with the stealing of my property, the kidnapping of my person, and charging me unlawfully where no statute actually exists, I am actually prepared to do battle with that. My arsenal super exceeds that of what the judicial system can provide. I have arsenal that is phenomenal. I mean, I like what I'm reading from. This is part of my arsenal, and actually, this right here is the major function of the arsenal. Without me behind it to execute it, it's just a mere book. So the book is kind of baseless and pointless and useless if it's not actually picked up, read, understood, and utilized in the correct manner. You know what I'm saying? Now, don't get me wrong. You could take this exact same book right here and utilize it to the wrong way, and it could go against you. But if you sit down, read it, study it, practice executing what you read, you will see that, whoa, these laws, they're powerful. They're very powerful. I can't even begin to express to you just how powerful these laws are. So anyway, let's get back into this, because now we're starting to get off into some of the juicy stuff which, yeah, we're getting ready to get into some of the stuff that's actually getting ready to get you guys' interest. And some of you may know it, some of you may not, but So let's rewind briefly. This is what the Hadfield court said of highway use. The former is a common right, as to the former, the ordinary right of the citizen to use the streets to be in the usual way. The legislative power is confined to regulation. The latter is an extraordinary use. As to the latter, the use of the streets as a place for business for private gain, it is plenary and extends even to absolute prohibition. Since the use of the streets by a common carrier in the prosecution of its business as such is not a right but a mere license of privilege, because the state may absolutely prohibit the use of the streets as a place for the prosecution of the private business for gain. There again, even though it was kind of written in a different text, it's also letting you know that the only authority the state has to regulate driving is in their business. So caution should be taken when using the term private, when used by the public state. Now, keep in mind, remember I was telling you about that, because I was telling you about private. Because there is a such thing as private carriers. So you have to learn to discern the difference between personal private automobile and private carriers. There is a distinction. There is a difference. And I was telling you guys that a while back. You can say, yeah, I'm private. Okay, you could still be constituted as a carrier. So you have to the wording. Remember, I was always stressing to you guys, wording. It is how you word it. If you do not word it correctly, it can come back and bite you in your ass. Caution should be taken when using the term private when used by the public state. The term private has a business connotation, because public business itself can be either common or private. As confidential between two parties, this writer recommends the term personal private in order to distinguish and eliminate any confusion that may arise. See, I just said that, right? I just said that. So that's what I'm trying to express to you guys. You can still have private commercial, because there is such thing. Personal private, there you go. The Washington State Supreme Court has long-standing declared the difference of the use of automobiles not inconsistent with the breadth of this document. When taxi operators had their licenses suspended, they appealed claiming loss of liberty. The word particular in this exemplar ruling identifies a factual distinction between personal conduct and commerce, and even suggests that one may use a company vehicle for personal use when not commercially engaged. And that's actually true even with 18-wheelers, because as a lot of you do know, I drove 18-wheelers. So you can actually put the vehicle in personal conveyance and drive it to a destination without actually being on the FMCSA time clock. You can actually put the vehicle into personal conveyance and drive to a location. Now, some of the trucks only have like 30 minutes. I do believe some have an hour. And I think if I remember correctly, some of them even had actually longer personal conveyance drive times, but they're not much longer. You know what I'm saying? So let's say, for instance, your clock stopped at, I do believe 12 hours. We'll say 12 hours just to be safe. So your clock ran out at 12 hours, but you're still a half hour away from a truck stop or a rest area. Okay? What you do is you pull over, you log out. Okay? Put your time in, put your clock on. Switch your clock over to personal conveyance, roll on to that truck stop. I've done it hundreds of times, hundreds of millions of times. I can't even tell you how many times. A lot of times. Let's just leave it like that. Is that legal within the confines and the laws and regulations of the FMCSA? Yep, sure is. It's on the clock and it even shows it. That clock digitally captures every single time that truck moves over 5 miles an hour. So when they see that and then they see that, oh, it's a personal conveyance, so you're not actually moving under the regulation of the FMCSA as doing business, as you're using it as your personal capacity motor vehicle. So you're utilizing that vehicle to get to a rest area. So that's in compliance with what was just read here. Yes, you can use your company vehicle as a personal vehicle. Yes, you can, because it is in the FMCSA. I've done it hundreds of times, as I said, and it is illegal, yes. Defendants are being prohibited from using a particular mode of travel in any particular way. State versus Scuffle. Now, again, remember when I was telling you all about the motor vehicle, or no, the argument came to me from someone saying that, well, you can't just use any particular mode of transportation that you want to travel. Yeah, you can. Law says so. The law says so. It says that they can't even tell you what type of mode of transportation you can and can't use. So for all you that came at me arguing with me about what you can and can't use, nope. Law says it right here that you can use any mode of transportation that you want. You know, it says you can use any mode of transportation you want. So the distinction of what type of mode of transportation you want to use is undefined. What's wrong, girl? Huh? What's wrong? What's wrong, mama? Am I being too loud for you? And my little Nala, she's my little girl. She she just got fixed, so she's not feeling too good, and I think I might be being a little bit too loud for her. I normally don't let any of them in the room with me while I'm shooting videos, but today she decided that she wanted to tag along with Dad, so she's in here with Dad. Okay, so the evident purpose of ordinance was to regulate and supervise the business of public carriers of passengers upon the streets of the city for the convenience and safety of the public. The license is required when one engages in that business and not when he used a vehicle for his own accommodation. What? What? Did you just hear that? Remember when we were all sitting there saying that, no, it says that you have to have a license, this, that. No. State versus Dunkley, 76, New Hampshire. Supreme Court case. Let's go back and read that again. The license is required when one engages in that business and not when he used a vehicle for his own accommodation. Now, if you're only issued one license and you're not required to have one when you utilize your automobile in that of your own capacity, you just been verified. You just been verified that you do not need a license to travel. You just been verified that you don't even need a license to drive. And even though we know that there's a difference between drive and travel, this case just verified that you are not required to have a license just to drive in your own accommodation. Ain't that some shit? Remember I told you, I got some juicy stuff for you. These are the case laws that were buried. I didn't even know that case law was in here. And I briefly skimmed through this book and read a lot of it, you know what I'm saying? But I did not read a lot of it. A lot of it has not been read. This book's over almost 200 pages long. You know what I'm saying? And now we just got assurance. We just got assurance that no license is required Let me read that again. Let's see. Let's go back up here. The evidence proposed of the ordinance was to regulate and supervise the business of public carriers of passengers upon the streets of the city for the convenience and safety of the public. The license is required when one engages in that business and not when he used a vehicle for his own accommodation. Mm, 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 mm. Mm, 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 mm. There it is, ladies and gentlemen. There it is right there. Oh, and by the way, just in case any of you are wondering, no cases has exceeded any of these cases. These are the power cases. Remember I told you about that these were the cases that were buried? These are cases that are buried within the Supreme Court and the courts of the whole United States. These are cases that they did not want people to know about because it already set the precedence. All the cases that you see online, 98% of them have been altered by someone to fit their agenda, their particular agenda, and whatever the that case may be, you know, regardless, what I'm reading to you here is not altered. It is not designed to fit my agenda because I don't have an agenda. The agenda I have and my goal is to fight for our rights that are being encroached upon from the government. So therefore, I have no reason to uh, commit fraud by altering case law to argue a point in court that actually is not, validated law. I don't desire and do not wish and will not ever do that. That's why I was telling y'all in previous videos, go back and read some of those laws. Because some of those laws, what is being said in those laws are not. It's not. They're not. I read some case laws that, man, I was like, that's too good to be true. That's way too good to be true. That can't actually say that. And then when I went to law library, and actually find found those cases and actually sat down and read those cases, as I do, as a lot of you do know about me and my history of case law. See, I don't go online looking up case law. I don't do that. I got a library that's not even 3 blocks away from my house. Okay? I walk straight to the library. I don't even have to drive over there. I just walk over there just to get some of the good old air. I walk over there, I sit down, and I pile books up around me, and I sit down in that law library. And it's usually me just by myself in there all the time. So, in doing that, I get to kick back, relax, and have 4, 5, 6, 7, 8 books laid out reading the laws, And yeah, you only can read one book at a time. But me, I'm the type of person that I will have 3 or 4 books laid out, open to specific laws. But what I usually do is I'll get the laws that I see online or that people in the comments leave, and I'll write them down, and then I'll go research them, you know. And then once I go research them, and then I find out that, oh, the sayings that they're saying that they have alluded to and said, oh, this is this and this is that. Not at all. Because in the law books you can even read the footnotes. And a lot of times some of those expressions you may find in the footnotes. Okay? It makes it legit. But when you go online and you see certain expressions that fit a particular situation, you have to question that and you have to go, Is this really that? Does this really mean that? More than likely, no. It don't. So be careful what you find online. Be careful. But you can take this one to the bank. It's cash money. It's 100. Like I said, I didn't even know this existed right here. This right here shocked me just now. That actually took me. That's why I'm sitting here going through this little whatever I'm going through moment with y'all, because that actually surprised the crap out of me right there. That actually surprised the living crap out of me. I was not expecting that. I was not expecting that at all. Mm, that's interesting. So the Supreme Court admitted right there. They admitted it. Wow. Wow. So now I am so see, and the thing is with this, man, is you for those of you that don't follow what we do, and you want to criticize us, again, you traders, you bootlickers, you you yeah, traders, bootlickers, you know who you are. Trolls. That's the other one I was looking for. Trolls. Uh, this affects me in a way that I am so elated. I am so happy because now I hear y'all. I hear y'all. I hear every single one of you guys. You trolls, you bootlickers. I hear you guys. You guys are crying now. You guys are out there going, oh my freaking God. What the hell? Yeah. And I'm glad. I'm glad. Because now that I found it, okay, now that I found it, you guys have no idea what this just did. You have no idea what this just did. I'm getting ready to exterminate. I'm going to be the troll exterminator. I'm going to be the traitor exterminator. mm, mm, mm. I can't believe that I found that. That's interesting. So, no license required. Mm-mm-mm. To travel in that or your own capacity. Uh-uh-uh. It's established Supreme Court law. Mm-mm-mm. Well, hmm, it must be an early day for the kids. All the kids are starting to come out, starting to come home. So, but anyway, yeah, ladies and gentlemen, I'm sorry for the delay and what I'm doing and all, but just what I just did, what I just read, it just kind of just it put me there. It took me there. Okay, that took me there because that's crazy. It took me there. I can't believe it. Let's see. Wait, we're missing a page. I do believe because that doesn't make sense. Oh, okay. I didn't finish reading the rest of the deal. In other words, the ordinance does not purport to regulate or supervise the mechanism of vehicles that are allowed to use the streets. It is only the business of public conveyance of vehicles of some kind that is subject to the supervision of the city. State versus Dunkley. That's the case, the Supreme Court case that comes out of New Hampshire that says the license is required when one engages in that of business and not when he used a vehicle for his own accommodation. Okay, so that's in that state versus Dunkley, 76 New Hampshire, 439/84/40. Read that case, guys. Read that case. Okay, that is the case. There it is, right there. That's the case. It tells you point blank and simple, no license required to drive your personal private automobile if you are not engaged in business. It says it. It's right there in black and white. In proceedings to punish for a violation of the regulation, the burden is upon the prosecution to show that the defendant is within the terms of the regulation and has violated it. City of Chicago versus Gall. On the trial of a charge of violating a provision without a license, it is necessary to prove that the accused was plying for hire. As an example, the placement of an automobile on public street where it is accessible to those who may wish to hire it, and the solicitation of passengers for hire by the one operating it by word, act, or exhibition of signs or devices. They're talking about taxis, obviously. Uber, Lyft, they're talking about that, you know. In the early 20th century, the state of Washington has ruled that personal and private use of one's personal automobile is perfectly legal and lawful. It is only under the auspice of a violation of commercial licensing statute policies that it could be said one has committed a traffic crime. The state would have to act in bad faith to rule personal use of public highways lawful, and then with superstitiously good lord, spurious intent dare to bring a criminal violation of a policy which offers no jurisdiction, no redress, and no authority over lawful conduct. What did I tell you? What have I been saying at the beginning of these readings? What have I been saying? What have I been saying? Where no policy statute is made, no law can be enforced. What did this law just say? What did this case just say? It says the state would have to act in bad faith to rule personal use of public highways lawful, and then with surreptitiously spurious intent dare to bring a criminal violation of a policy which offers no jurisdiction, no redress, and no authority over lawful conduct. Personal private automobile is lawful conduct. No jurisdiction. State has no jurisdiction over it. Personal private automobile, they have no jurisdiction over it. That's why I've been telling you, no law can be enforced and no jurisdiction exists where no policy or statute has been written. There is no statutes or policies written on personal private automobiles. There never has. It never can be written. No law has ever been established and or written in reference to personal private automobiles. And as you saw back here in this law right here, the state versus Dunkley, it specifically states in there, no license required to drive in your own personal accommodation. Supreme Court law. Ladies and gentlemen, it is a fact. It isn't a fantasy. It isn't delusional for all you trolls and you oh man, I don't know why I can't get those three things down pat. Trolls, traitors, y'all, constitutional domestic terrorists or whatever, for all you people who believe that the law says you have to have this because if you don't have this, you can get this, okay? But the law actually says this, my brother. The law says in specific the license is required when one engages in that of business and is not required in that of his own personal private accommodation. Says it. Sorry, it says it. It's the law. So you can come at me however you want to, but you know what? When you come at me, you better come correct because I got power. And if you know of a case that supersedes this case, bring it. Bring it. You're not gonna find one. There ain't one. I'm almost sure there ain't one. But you can rest assured of this and believe this. I just found this. I just seen this. I just read it. I'm damn sure gonna research it. Goddamn right, I'm going to research it because that, like I said, in a kind of way, how I told you, like I find cases online and stuff, and I see them, and oh, that's too good to be true. Well, to a degree, this right here kind of leaves me in that footprint, but it also leads me to say, well, wait a minute. There's nothing in this book that's altered from what I've seen online because when you go online and you see those cases, yeah, they're exaggerated and they are altered. But when I read this, a lot of the cases that I've found in here that I have seen online, not even close, not even close. So I believe that this right here, this right here, that answered the question. So I'm glad that I found it, and I'm glad that I was able to share it with y'all because it's crazy, But like I said, you know, where no statute or policy has ever been written, okay, no law can be enforced, no jurisdiction exists. So therefore, the states do not have jurisdiction over private travel. And you don't have to become a private citizen. You just tell them, I'm private. Take your plates off your car. Now, keep in mind now, my advice, okay, let's make sure we get this disclaimer out there, okay? This is for educational purposes only, okay? So I'm not a lawyer, okay? I'm a rights activist. Always have been. I've been one since I was young when I first learned what rights was all about. And I've been actively involved for a lot of many years. So I've actually gotten to the point now to where I've been established to the point to where I've gotten a good little group, you know. Now granted they don't follow me here, but then again I don't have a lot of people that do follow me on here. And that's okay. But regardless as to how many followers I have, I don't care about that. I don't care about how many subscribers I got. I don't care about any of that. If you are following me and you're for the cause, I love you all. Amen. If you're here because you are a troll, you're a constitutional traitor, uh, that, hey, I love you guys too. Because it's you that I'm actually directing all this towards. It's because it's you who are putting us down for doing the right thing when you aren't even bold enough to step up and do the right thing. You're a coward. You hide behind, you sit there and you get on here and you want to be a text warrior. All of a sudden you're a gladiator because you can talk through text and you can message people and you can sit there and belittle people and you become a media warrior. I'm not a media warrior. I'm a doer. I'm a leader. I'm a king. And I walk in that of kingdom because of the simple fact is I believe and know that what I do is right. Yeah. And I'm gonna tell you something. I've been to prison, been there, done that. You know what I'm saying? Been locked up numerous account of times. But here's one thing I can tell you that a lot of people don't know. Okay, I've had charges come back from back when I was young. done time, done a lot of time. I've had a case in Texas where I was wrongfully accused, and I did 12 years on that case. During the course of that 12 years is actually where I learned law, because that was the case where I knew that I was wrongfully accused, and I knew that I was going to have to go through an appellate system to win this case, if it was even possible. You got to keep in mind, this is Texas. Texas is the #1 state for the most unlawful and wrongful convictions. So that within itself speaks for itself. During the course of that 12 years, the first few years, man, it looked very bleak. I didn't think that nothing was going to happen because of the responses I was getting back from the courts, etc., etc. But like I said, I was actually new to, you know, the law. So I mean, I wasn't new to the system, because I'd been in and out of the system for a long time, growing up as a troubled kid, coming up and being the way that I was. But then once I finally settled into doing my time, started taking the time and spending countless hours in the library, it's where I started to learn how to read the law, apply the law. That's where I was getting my deal. So to make a long story short, I ended up winning the appeal. Okay, after 12 years, I won the appeal and got it. So after 12 years, case dismissed. I went back into the record and found some of my older cases that were, older than that particular case. And I started addressing those cases. And they were talking about, well, statute of limitations. I'm not trying to appeal the outcome of these cases. I'm trying to get these cases expunged, get them off my record. I did. I was successful. I got them all off. I had one when I got here. And, it was interesting because the DA, when I was here in this case, I was said to have struck my wife, which it didn't happen. But someone called in and told them that, oh, there's a guy and a girl out here arguing, da 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 da, and they didn't even know what was going on between me and my wife at the time. Me and my wife weren't even arguing. We were just out there having a heated conversation. And I guess from that person's point of view, it looked like I had struck my wife. Well, it didn't, so they corralled my wife, harassed her, and told her that she needed to do this, she needed to do that, and all this stuff. And my wife was just like, what? This man never put his hands on me. Why the hell would you guys even come at me? Well, we got to report that. But here was the interesting part about this. They got a report from someone, right, who never actually filled out a report. Interesting, huh? So anyway, when that case went to court, all charges dismissed immediately. So, I mean, it's the system. The system. When the prosecution decided that they wanted to drop the case, the charges, the judge asked in reference to why. You know what the prosecution said? Prosecution said, we cannot prove his character, and we have no evidence of a criminal background. We have no evidence. We have little or no evidence to substantiate who he is. We have no connectivity to him. No, you don't have no connectivity to me. You don't have no contracts for me, is what it is. Because I went back and eliminated them all. I eliminated all my contracts. Got rid of it. Got all those records expunged. Got them all closed. Even though I know that through the system they're still alive, however, they are officially closed, and you cannot actually go into those records unless you have a warrant. Simple. Warrant. You have to have a warrant. So there you go. Yeah. Oh, and yes, what I just told you is on record. It is actually on record, where the prosecution is saying that they could not substantiate and or confirm any evidence proving my character, that they could not find a criminal history or record of me, etc., etc. And as I just told you, yeah, I had an extensive criminal record. My family can confirm that. They can confirm the fact that, yeah, he was in and out of prison and jail, you know, and all the time. You know, he was a troubled kid, you know. Troubled kid, troubled young man, however you want to label it, it don't matter. Past is the past, you know what I'm saying? But I do want you to know and understand, you know, per society's, uh, what do you call that? Where you take and you make, oh, I can't even remember the term that I'm looking for right now. There's a term that they utilize, that you have been stereotyped. There you go. So they always say that, you know, once you enter into this type of activity, you never get out of it, you know. So your past establishes who you are in the future. That's not true. Your past does not establish who you are in the future, which in fact is another part of what I'm doing, trying to get the courts to make some type of ruling on, is the fact that, you know, per the Second Amendment, our gun rights, they say that if you have a felony, you can't apply. Well, shouldn't you put a statute, some type of statute on there, that if you haven't committed a felony within so many years, that your past should be excluded from the record? Because what if you are an outstanding citizen now, you know, and you no longer uh, engage in that type of activity? What, just because you had a red flag on your record from back in the day, that constitutes or stereotypes you to this day that you're still that same criminal minded individual? It doesn't prove that you're that type of individual. It does, you know, it does confirm who you was then, you know, but it doesn't confirm who you are now, you know. But anyway, all that's neither here nor there, and that's, you know, that's just a little insights, and just, you know, getting in there and putting some things out there for you guys, you know, to know. So, you know, yeah, I think what I'm going to do is, this video has actually gotten a little bit longer than what I actually thought it was. So yeah, I think this is, we're going to have a lot of parts to this, because, you know, there's just too much to say. And I'm just going to be honest with you, after having read the case that I read, it kind of just took me to another place, you know. And I and I haven't I've actually still got the page right here. So, you know, I actually have to go back, and because I'm going to look this case up, because I need to see the date on this case. But regardless of it, it is a Supreme Court case, and it it has precedence, it has power. Like I said, I don't believe that this case has been superseded. What's up, honey? Okay, Daddy's getting ready to get off in a minute. Okay, I'll let you out in a second. Hang on. All right. So, well, check it out. So, I'm going to be making another video here later on this evening, which I will do, because I am up, moving around, and I'm actually starting to feel a little bit better. Take a couple more allergy pills, and I should be good to go, hopefully. And we can get beyond the case that I just discovered, and we will get off into some more better stuff, and maybe a little less rambling on about other things, and get into the points of interest. Okay, and again, I apologize for the length of this video to everybody. I apologize for the rambling and carrying on and going on, and you know, but the next video, part 3, we'll get off into it better, and we'll get a little bit more information in. We'll get more information in than we will just casual talk. All right. So, with that being said, this is our Dark Angel. I'm out of here. Until the next video, which will be here in a little while. I just want to tell everybody I hope you have a beautiful, blessed day. And Dark Angel was out. And deuces.